Welcome back to Mariner Pro. Listen, your seafarer contract is the single most important document you have. But let's be honest, it's often a minefield of hidden traps. So today, we're breaking down the 9 critical red flags you absolutely must spot before you sign anything. This information could literally save your career, so you're gonna wanna stick around.
Just think about that for a second. It's one of the most common and most dangerous mistakes in our entire industry. Signing without reading is like setting sail without a compass. You're just giving away all of your power. Well, today, we're gonna change that. Okay, let's dive right in. We're gonna start with the fundamentals. These first 3 red flags, well, they're the absolute non-negotiables. If you see any of them, alarm bells should be going off like crazy. Now, this first one might seem obvious, but you would be shocked at how often this happens. It's the blank contract. An employer asks you to just sign a document with a bunch of empty fields, promising, oh, don't worry, we'll fill them in later. Look at this POEA form. A blank contract like this isn't an act of trust. It's a trap. When you sign it, you are giving the company a blank check to write whatever terms they feel like. Your salary, your contract length, your rights, all gone. The rule is incredibly simple. If it's blank, you walk away. Period.
All right, next up is red flag number 2, missing core details. You know, international law, specifically the Maritime Labor Convention, or MLC 2006, actually mandates what must be in your contract. Let's take a look at that checklist. This is your MLC 2006 checklist. It covers everything from your personal details and wages all the way to your repatriation rights. Every single one of these items must be spelled out clearly in your Seafarer Employment Agreement, or SEA. If even one is missing, that contract is non-compliant and it puts you at serious risk.
Red flag number 3 is a big one that a lot of seafarers overlook: the absence of a collective bargaining agreement, or CBA. If your contract mentions a CBA but you can't get a copy, or even worse, if it doesn't mention one at all, you need to stop and ask why.
It is so crucial to understand how these 2 documents work together. Your personal contract, the SEA, usually just covers the basics. The CBA, that's where you find all the important details on overtime benefits and dispute procedures. Your SEA incorporates the CBA by reference, so if you can't actually review the CBA, you're basically signing a contract with half the pages ripped out.
All right, we've covered the basics. Now we're going deeper. This is where things can get really deceptive. These next 3 red flags are the hidden traps, the clauses that are buried in the fine print, designed to take advantage of you. This is where you need to put on your detective hat.
Red flag number 4 is vague language. This is a classic trick. Phrases like subject to company policy are intentionally ambiguous. And you know why? They give the company all the flexibility and leave you with 0 protection. I mean, just look at the difference here. The dangerous clause on the left is a total black hole. Company policy can change whenever they want. The protective clause on the right, it's crystal clear. It states the exact wage and it references the CBA for overtime. You have to demand this level of specificity, always. Red flag number 5 is a really serious one. It's any clause that lets the company change the contract without your consent. This turns your agreement into a one-way street where only their interests are protected. Nautilus International puts it perfectly. Your contract is a mutual agreement. It cannot be changed at the sole discretion of the shipowner. If you see language like this, it means your contract length, your duties, even your pay could be changed on a whim. That's not a contract, that's a surrender. Red flag number 6. This one deals with the worst case scenarios. And I know we don't like to think about it, but we have to. What happens if you get sick, injured, or worse? If your contract is silent on compensation, you're dangerously exposed. The crucial point here is that verbal promises are completely worthless. Your contract must have specific, written compensation details for all of these scenarios, from sickness and injury to premature termination. This is your safety net. Don't you dare settle for anything less. Okay, we've seen the traps. Now let's talk about your power. These final 3 red flags are all about the fundamental rights that you possess as a seafarer. Knowing these gives you leverage. This is where you stand your ground. Red flag number 7 involves any contract that tries to ignore your right to go home. MLC 2006 sets very clear limits on service time. This is about your well-being, and it is absolutely non-negotiable. Remember this number, 11 months.
That is the maximum accepted period of continuous service before you are entitled to repatriation. Any contract that tries to push beyond this or makes going home conditional is violating your rights. You have the right to go home. Red flag number 8 is all about fairness. How can the contract be ended? Well, an unfair termination clause is often incredibly one-sided, giving all the power to the company and leaving you with absolutely none.
Here's exactly what unfair looks like versus the MLC 2006 standard. A 24-hour notice for them and 30 days for you? No way. That is unacceptable. The law is crystal clear. The notice period cannot be shorter for the ship owner than it is for the seafarer, and it must be at least 7 days. And now, we have arrived at the ultimate red flag, the biggest, the brightest, the most unacceptable warning sign of them all. It's any attempt in any way to prevent you from contacting a trade union. Let me be absolutely clear about this. This is not just a red flag. It is illegitimate. Your right to freedom of association and to seek advice from a union like the ITF is a fundamental human right, and it's protected under international law. Any company that tries to take that away is showing you exactly who they are. They are a bad faith employer, and you should not work for them. So let's bring it all together into your pre-signing protocol. It's simple. First, you review everything. Second, you get that CBA. Third, you seek advice from a trusted source. Fourth, you never, ever sign under pressure. And finally, you always keep a signed original for yourself. This protocol is your power and it's your protection. Your contract defines your life at sea. So, are you going to let it be a trap or are you going to make it your shield? If this was valuable to you, hit that like button to help other seafarers find this information and subscribe for more content, including our upcoming negotiation tactics. And most importantly, share this with your crew because knowledge is power. Thank you for watching Mariner Pro. Fair winds and following seas.